So in these remarks, I intend to deal with basically three main issues. I want to explore the relationship between the Hague Conference and Africa. I will highlight some areas of positive achievements and also point out some of the emerging issues and areas that are in need of attention. I'll start by noting that in 2006, I published a paper in the Yearbook of Private International Law, which was entitled The Hague Conference and the Development of Private International Law in Africa, a Plea for Cooperation. In that paper, I explored how Africa's engagement with the Hague Conference can further develop the subject at both national and continental levels, and also help to resolve conflict of laws problems on the continent. At the time of writing that paper, Africa's engagement with the Hague Conference was modest at best. Only 3 African countries were members of the Hague Conference. Those were Egypt, Morocco, and South Africa, while 18 African countries were party to the conference's various conventions. African intellectual and academic investment in the work of the conference was also minimal, with very few academic papers addressing the conference's work from an African perspective. My paper advocated for increased cooperation between the conference and Africa and noted that the channels for cooperation are many and can be mutually beneficial. Cooperation between the Hague Conference and Africa has increased significantly since 2006. In fact, conclusions of the 2015, 2016, and 2017 meetings of the Council on General Affairs and Policy have noted the necessity of expanding the organization's work globally, including throughout Africa. Furthermore, in 2015, the Permanent Bureau developed an African strategy and had it approved, which it is currently implementing. Since 2006, Burkina Faso, Mauritius, Tunisia, and Zambia have become members of the conference. A number of African countries that were previously not party to any Hague Convention have also become party to at least one convention. And here I have in mind Gabon, Ghana, Kenya, and Rwanda. So far, the Inter-Country Adoption Convention and the International Child Adoption Convention have been popular with these new countries. In total, in addition to the 7 African states that are members of the conference, we have 22 other African states that are party to one or more of the Hague Conventions. It's also noteworthy that a number of judicial and other conferences with a focus on Africa have been held by the conference or under the auspices of the conference. These include an international conference on cross-border cooperation in civil and commercial matters, which was held in Morocco in 2014. And in 2015, there was also a conference on commercial private international law in East and Southern Africa, which was held in Johannesburg, South Africa. More recently, in November 2017, the conference, in collaboration with the African Foundation of International Law and the Hague Project, hosted a group of African Chief Justices and other judges from Africa. This effort to integrate the work of African judges in the work of the conference is definitely positive. Indeed, there have been a number of instances in which African judges have made reference to Hague Conventions in their judgment, even at times when their respective countries were not party to the relevant convention. Notwithstanding these positive developments, Africa is the continent least connected with the Hague Conference. And if you look at the color of the faces in this room, you will definitely see that this is true. Thus, for the Hague Conference to remain the preeminent organization that develops high-quality solutions in the area of private international law, the conference's current level of engagement with Africa must be enhanced. The conference has the opportunity to address challenges in Africa's legal landscape, especially in the areas of commercial law and family-related conflict of laws issues. Moreover, the expansion of regional economic integration and increased foreign investment in Africa demand a rethink of some of the existing conflict of law rules. These developments provide the conference with opportunities to engage with legal issues of continental importance. Currently, the African Union has recognized 8 regional economic integration organizations on the continent, the East African Community being the most developed one, it being a common market. Throughout Africa, increased cross-border transactions resulting from economic integration and foreign investment raise important issues, such as the extent to which courts will uphold jurisdiction and choice of law agreements, as well as enforce foreign judgment. In this regard, it is noticeable that some African governments have enacted legislation that potentially will undermine the effectiveness of choice of forum and choice of law agreements. An interesting problem that has resulted from regional economic integration in Africa is the issue of enforcement of judgments of regional courts in national courts. Most of the African regional economic communities have courts of their own, which allow individuals to litigate before them. There is uncertainty as to how an individual who obtains a judgment from such regional courts can enforce it at the national level. For example, in one South African case, the South African court had to adapt the common law regime on enforcing foreign judgment in order to enable it enforce a judgment from the Southern African Development Community Tribunal, which is a regional court. The same judgment was denied enforcement in Zimbabwe because, according to the Zimbabwean court, that judgment was contrary to public policy. More recently, the High Court of Ghana refused to enforce an $800,000 judgment obtained against the government of Ghana from the ECOWAS Court of Justice. I think instruments such as the Hague Choice of Court Convention and the recently adopted Hague Principles on Choice of Law in International Commercial Contracts could provide internationally accepted solutions to some of the emerging issues. In general, the Hague Conference conventions can serve as models for the development of regional instruments as well as national laws. Effective first steps should definitely involve the conference's continuous promotional work with African government, judges, and policymakers. There is definitely the need for the conference to strengthen its relationship with the African Union and African regional economic communities. In the area of family law, international adoption and surrogacy are 2 important subjects. In June 2015, a special commission of the Hague Conference adopted a declaration on the need to develop a harmonized framework for the adoption of children from Africa. The recent decision by the Ethiopian government to ban foreign families from adopting Ethiopian children definitely cast a spotlight on the adequacy of the international legal infrastructure that facilitates the adoption of children, and the extent to which that infrastructure serves to prevent abuse and neglect abroad. Like many African countries, Ethiopia is not a party to the Hague Adoption Convention. The international aspects of surrogacy is also generating some interesting cases in the absence of legislation on the issue. In a 2014 Kenyan case, the court describes surrogacy as, and I'm quoting, not a hypothetical issue anymore. In a more recent case, the court noted that there is no doubt that in Kenya, we require a law to regulate surrogate agreements, in order to protect all involved and the affected parties, including, most importantly, the children. South Africa appears to be the only country that regulates surrogate agreements with legislation. However, the South African legislation does not deal with the international aspects of the subject. The conference's continuous work on private international law issues surrounding the status of children, including issues arising from international surrogacy agreement, is welcome. The conference would stand to benefit from seeking relevant input from African countries and experts as these works advance. As I noted in the 2006 paper, the absence of African participation in the negotiation process may lead to situations where the interests of Africa are not fully accounted for during the negotiation process. To this end, in developing conventions, it will be useful to extend consultation, including relevant questionnaires, to non-member states so that their perspectives can be brought to bear on the work of the conference. As the former Secretary General of the conference, Professor Hans van Loon, noted in his recent Hague Academy inaugural lecture, and I'm quoting, he noted that negotiations must be more inclusive and responsive to the needs of a growing number of developing countries, unquote. Finally, an important missing link between the Hague Conference and Africa is the absence of a physical presence on the continent. Consistent with the organization's 2002 strategic plan, the conference should expedite the steps required to establish a physical or representative presence on the continent. The conference currently has regional offices in Argentina and Hong Kong, both of which have been lauded for advancing the work of the conference in their respective regions. While compared to other regions of the world, only 29 African countries are party to one or more of the Hague Conventions. This is not an insignificant number of states. The conference's increased engagement with Africa is critical to making it a truly universal organization. Thank you.
Richard, thank you very much indeed for these very thoughtful comments, which provide almost a list of bullet points to go through for providing work for the next years to come. You know that Africa has been identified as a priority. I would like to stress that I made it a point, an explicit point, that my first official mission would actually take me to Africa to underscore and underline the importance of Africa as a strategic development. For the record, I have to stress that the Africa strategy was formally not approved. What the Council did do, however, is that it identified universality as a tenet for the Hague Conference as a strategic direction, and developments in Africa were very much part of this development, but the strategy as such has not been approved. But that is not an obstacle for us to continue to develop efforts, try to increase the visibility in Africa. We do it through a cooperation with the East African Union, for example. For the Upper Stee Convention, we had a joint program with them. We have a cooperation agreement with OHADA now that we try to develop. We're still trying to seek the proper channel to reach out to the African Union and see how best to work with them. And I would love to do this with you and your colleagues, and rely on your advice, Richard, because your efforts in Africa to promote the work of the Hague Conference are not just welcome, but really very important. The regional office, now I really have to be careful because this is a touchy matter. You know that the members of the Hague Conference have asked us to develop a framework for future regional offices, and as I said in the opening remarks, it's complicated, and leave it at that. But talking in a personal capacity, I can certainly express my full agreement with you that the Hague Conference needs, in my view, actually at least one regional presence in Africa. But the continent is so huge and vast and different in many respects that we probably need more than one regional presence. But close parent, because again, I know how delicate the subject matter is, and I recognize that.